and who do you want to receive the benefit.
Okay. Now, another thing that we talked about is avoiding getting into court just because our court system, particularly in California right now, is sort of in chaos because of the budget situation. Would you like to comment about that a little bit?
Sure. I mean, I think for years, ever since I started practice 30 years ago, in the kind of in the mid 70s, where right when I started to practice, there was what we call the revocable trust movement, and people basically had the idea that they wanted to avoid probate and court costs and statutory attorney and executor fees, and they set up their estate plans in the context of a living trust. And I think that's really been a positive movement, and the California legislature and legal community really has embraced it and said, yeah, this makes a lot of sense. In the average person situation, if you have a living trust, you don't have probate, you don't have to go to court if everybody gets along, you don't have statutory fees, so you're really only paying attorney and executor and management and trustee fees to the extent that the services are actually needed. And it's very, very quick. You don't have to wait for, statutory periods and all of that. And so, at least in terms of creditors. So it's a very efficient system that's built in, which should be utilized. But in order to access it, the toll charge, so to speak, is a living trust document. And they're very readily available. There's a lot of attorneys who specialize in, doing living trust systems for people at very reasonable cost. So, in order to access what's available under California law, which is to avoid probate and avoid all these statutory charges, it's important that people do some estate plan and take positive action in terms of getting a revocable living trust system.
Okay. Okay, so another thing that we talked about recently is that there are other changes that are going on. For example, in California, we have some changes happening with no contest clause, as I understand it.
Oh, I think that's an excellent point as to why people need to review their estate plans, because there are some changes, and the no contest clause is a good change. I mean, I'm not sure, being an older practitioner, it's such a good change.
It's an important change.
It's an important change. Okay, it's an important change and a good example of why people need to review their estate plans, because you don't want anything that's not anticipated. And so it's worth it if you go in and spend an hour or two with a lawyer going through your trust, going through your no contest clause, and communicating to the lawyer exactly what your wishes are with regard to people contesting your will or your trust. And then the lawyer can explain, okay, under the new law, here's what you can do, and here's what you can't do, and here's what's dangerous, and here's what's not dangerous. And as with most legislation, there are a lot of traps for the unwary, so you want to avoid those.
Okay. So anyway, so now we've given you a definite reason why you need to go meet with your attorney if you have a no contest clause in your will or trust, to make sure that it's effective and you understand what it does. Let's talk a bit about the basic documents that are the foundation of the estate plan.
Well, I think the systems, really the way to look at modern estate planning is on a systems basis. And here we are in Silicon Valley, and we're all systems oriented. I remember when I wanted to be kind of part of the community here, you'd go to these parties at your kids' schools, and they'd say, well, what do you do? If you said you were a wills and trust lawyer, people would say, oh, well, gee, I don't want to talk to you. But if you said I design and implement fully integrated wealth planning systems, they'd say, wow.
Wow, I wonder what that is.
I wonder what that is, yeah. So you get their attention. And so anyway, You know, but it is a system, and really the cornerstone of the system is the living trust document for all the reasons we said. It avoids, you can do all your tax planning in the context of the living trust, you can avoid probate, and you don't need any court supervision. So it's the cornerstone. Then you have some other documents which are support documents. One of the support documents is a pour-over will. It's critical to have a pour-over will because what that does is that seals the trust. Because you know, if people say try to sidestep the trust, it's let's say the linebacker, if you will, because it's the one that can enforce the you know, the terms of your trust by making sure that anything that goes into your estate gets poured back into the living trust. So it's a critical document because it actually seals the trust, if you will.
Okay.
Another important document to have are powers of attorney, okay? And you say, well, gee, if all your assets are in the trust and they're managed in the trust, why do we need a durable power of attorney? Well, you need a power of attorney, and we want it to be durable to survive any incapacity, because there are a whole bunch of other financial matters like benefits and public benefits, private pension plan benefits, legal contracts that may be enforced, which are really outside the purview of your assets, but you need somebody to take some action on your behalf to enforce the contract, to enforce your benefit rights under the plan, and so the durable power of attorney holder is the person that has that. So it's a very important document. And then last but not least is the healthcare directive, and I think the healthcare directive, allows you to avoid the unfortunate situations kind of highlighted in the media with the Terry Schiavo case. Okay. See, the Supreme Court gets a lot of blame for things, but it really isn't the Supreme Court's fault. They have a very sensible rule, in my opinion, and that is you have an absolute right to refuse medical treatment. It's an absolute right that you have, but the state has a right to say, you need to exercise that right in writing so that we know for sure. And I think that makes a lot of sense, because then you don't have these hearings where we're dealing with hearsay evidence, because of course the problem is you can't ask Terry Schiavo, what do you want, and so people are trying to give allegorical evidence which may or may not have weight to make these determinations. So it's much better to have you say in no uncertain terms what you want in that regard, and you can do that through a healthcare directive.
Okay, good. Okay, so we're going to go a little bit through some of the ABCs here for our viewers again, in the basics. So what are some common trusts that are used in an estate plan? Well,
the first one is, and the one that I think many average people utilize, is just a simple, we'll call it a disclaimer trust mechanism. In other words, people leave it all to the surviving spouse. If the surviving spouse, because of a reduction in state tax exemption, it's prudent to set up a separate trust for tax planning, they can do that. Now, so that's one trust that's very popular with my clients. One drawback to that trust is that if one of the parties is uncomfortable in leaving everything to the surviving spouse, because they fear that, gee, we're really young, we're in our 40s, and if something happens to one of us, probably the survivor is going to get remarried, and then, how do I protect my kids, because I don't want my surviving spouse to get my entire estate and then pass it on to a new spouse. You want to have some controls over that. You can set up what we call a family trust, and